Appeal number 84, the people of the state of New York versus Michael Prindle.
Good morning, Your Honors. Good afternoon.
Good afternoon, sir.
If I may, I'd like to reserve 2 minutes for rebuttal.
Yes, of course you may.
May it please the Court, on behalf of the appellant, Michael Prindle. Based on this Court's prior interpretations of the PFO statutes and based on the text of those statutes, Mr. Prindle remained eligible for a non-PFO sentence as low as 3 to 6 years, even after the Court had found 2 prior qualifying predicate convictions. He became ineligible for that lower sentence and subject to a higher sentence only after the Court made additional findings of fact that went well beyond.
Counsel, Rosen, Rivera, Battles, Giles, many times the arguments have come up to the Court and been rejected, albeit with some very compelling dissents, but nevertheless rejected. What's different today in this case than in every other case where we have upheld as constitutional the PFO, of course, based on a particular reading that this Court has taken of that statute?
Every one of those cases dealt with the authorization of a higher maximum, basically. They dealt with the authorization problem by saying that it's the step 1 findings.
But why does the analysis change any if now we know that it also applies to the bottom end? How does that change the analysis?
Because after the step 1 findings, it's clear, and Rivera and Quinones say it explicitly, after the step 1 findings, he could still get a non-PFO sentence, meaning that the minimum has not moved up at all.
That's true with the maximum as well.
Well, the courts expressly held that the maximum moves up at step 1, based on the prior convictions. That's when the sentencing ceiling goes up. That's the key.
I thought we held that the range moves after a determination of the prior felonies.
The top end of the range, exactly.
No, the entire range.
If the entire range moves up, then step 2 is pointless. I don't know what happens at step 2, but if the bottom end of the range is not moved up, then that's a pointless exercise.
My understanding is that if there is discretion under step 2, and the Court finds in its discretion that PFO sentencing is not required, because step 1 entitles the judge to order PFO sentencing. Step 2 is, these factors, in my discretion, no. We're going outside the PFO range, and we're going back to the second felony offender range.
If that's the way you want to put it, I think that's fair enough, but which suggests to me that there's no mandatory minimum created after step 1. There's still a possibility of going down below it.
Well, there's just as much of a mandatory minimum as there is a mandatory maximum. That is that the Court can go outside that range.
But the Court can't go outside that range once it's made the step 2 findings.
No, once it's made the step 1 finding. After the step 1 finding, if the Court, in the exercise of its discretion, does not make findings that a PFO sentence is required, then the whole range changes.
Let me try to explain the position this way. After the step 1 findings, you're suggesting the entire range moves up. And then step 2 allows the Court to exercise some discretion to go back to the old range, right?
That's how I understand.
Once the Court makes step 2 findings supporting a PFO sentence, that's when the mandatory minimum kicks in. That's when 15 to life becomes the minimum. And I have 3 sources of support for that.
But doesn't the maximum also, why wouldn't that also kick in the maximum, which would be life at that point, right?
I mean, I believe, well, I'm talking about the whole sentence, 15 to life versus 25 to life. The maximum moves up to 25 to life. It becomes available, it becomes authorized after step 1. That's the key to this Court's position. My position is that
the minimum moves up too.
Right.
But he then becomes he's clearly eligible still. He still has the possibility of receiving a lesser sentence at that point, because that's the whole point of going through step 2. If Rivera and Quinones have especially said if he can convince the judge that there are mitigating factors here, and if the people don't carry their burden of proof step 2, the judge can certainly exercise its discretion to impose a non-PFO sentence.
One of your arguments is that the other states have done this, right? Connecticut is one state that has overturned their equivalent statute, right?
The amici make that point, yes, that's true.
That was done in 2007 in response to Blakely and Cunningham, not in response to Lane and the minimum, because it's the same type of thing. And if you find it as it does the maximum or the minimum, they're both moving up. We've already ruled on this a number of times since Cunningham and Blakely. So if we were going to do it for the reasons Connecticut did it, on a same statute, we would have done it before.
I don't make that argument in my brief. I think that's a bit of evidence that this court is standing alone outside of the practice that everyone else has taken, and that, that maybe it should be reconsidered. But that's not the core of my argument. My argument is not focused on what the other states have done.
So let's break it down then. So as a persistent felony offender, the range is what?
Well, the people's position is that the range after step one is from the top of the PFO range of 25 to life, all the way down to the bottom of the second felony offender range, which in this case would have been 3 to 6.
Right.
I'm agnostic about whether or not that's the full scope of the range. I think those are two separate ranges being conflated there. My position that it's, if you're going to be sentenced as a PFO, it's 25 to life at the top end to 15 to life at the bottom end. And that bottom end is not a fixed minimum, there's no mandatory component to it until after step two. Step two allows the court discretion to go below that, and step two ends the court's discretion to go below that.
But I don't understand why the maximum, that same argument doesn't apply to the maximum. Because until after you make the findings at step two, you can still, the maximum is a lower amount depending upon the crime involved.
As the court has interpreted Apprendi and its progeny up until Lane, it said that the problem is about when a sentence is legally authorized. So when that 25 to life maximum is authorized, right? It has never considered the Elaine issue. Elaine expressly says whether or not a particular sentence is legally authorized is beside the point. We have another Sixth Amendment problem. And the other Sixth Amendment problem is when it becomes mandatory, when the defendant becomes ineligible for a lower sentence in the lower half of the range.
Can I ask you a different minimum maximum question? When I look at the papers in Supreme, this is particularly the affidavit of Mr. Brazil on the PFO status. In paragraphs 8 and 9, all that he's complaining about is the imposition of a maximum sentence to impose a life sentence beyond the otherwise imposed maximum sentence. And you're now arguing something having to do with Elaine about the minimum sentence. I wonder what you preserved.
I believe it's adequately preserved. I mean, Elaine shares with Apprendi the general premise that any fact finding that aggravates the range.
I understand that, but I'm asking if you argued anything about the minimum in Supreme.
Not expressly, he articulates the major premise under Apprendi that's consistent with Elaine. He doesn't articulate the minor premise, but that was a premise that was ruled out by Harris, which was standing law at the time, and it would have made no difference. The court would have just said, no, the Constitution is against you on that point as well. And as I've cited in my brief, there's plenty of case law from this court saying that if, a new constitutional theory, if the constitutional objection is made and a new sort of theory becomes available based on intervening Supreme Court case law while the case is pending on appeal, that's all you need to do to preserve it. Here, there's no factual issue that wasn't developed that would have been developed otherwise. It's clear that we were objecting on 6th and 14th Amendment grounds under the case laws that existed at the time. I don't see what difference it would have made if someone had imagined that Harris might get overruled.
Thank you, Mr. Hub. Counsel?
Thank you. May it please the court, Leah Mervine on behalf of Monroe County. Good afternoon. I think that's the most salient point, what Judge Wilson raised about the preservation issue. It is the people's position that this case is not preserved for this court's review. If New York's...
But you didn't actually make the preservation argument that I just stated, right?
We did make
A different preservation argument, no?
I do believe that we made it in the court below at the Fourth Department as well as before this court. We made a two-pronged preservation argument in our brief. And the key prong, I think, is the fact that Aileen post-dated the notice of appeal in this case by 2 years. And I would agree with Mr. Hobbs if this issue had been raised of a minimum and a maximum based on Harris.
What about the illegal sentence exception to the preservation rule? Why wouldn't that apply?
If it were to be, and this becomes almost like a chicken and an egg issue, and I think that was raised in the reply brief.
Right, we would have to determine first whether it was illegal to determine whether it was preserved, right?
Correct. So that, I mean, that could be perceived as an exception to the preservation rule, but it could also circle back again, and once the merits are examined, it could go back to preservation, if that makes sense.
Okay, but so we can do that then?
Right, well, and I think that's sort of how preservation is illusory in a sense, is that you can raise preservation and then there could be a merit and that could be found. But in this case, I believe that preservation, even after the merits are considered, will be the dispositive bar, because this state's jurisdiction has never relied on Harris. And when Harris v. United States was addressed, that was the Aileen case. So Aileen has done nothing whatsoever to change the jurisprudence in the state. And going back to the preservation issue, our two-pronged argument was, one, that, again, in quoting Mr. Brazil's objections, he was saying he believed that the United States Supreme Court in Battles was going to reach this issue and change New York's law. It never did. So that is the preservation that, you know, if Battles had changed, then perhaps it would be preserved. But secondfold, Aileen didn't even exist at the time that this case was being considered, and there was never an argument made about an expanded minimum. And that is the only thing that Aileen addresses. And I think it's really important to point out that this court has said in Rivera that it will follow Almendarez-Torres until the Supreme Court rules otherwise. And we're going back to 1998. The U.S. Supreme Court has had multiple opportunities to change its position, and it never has.
Ms. Mervine, once step one is satisfied, what's the range, the authorized range of sentence?
I believe the authorized range of sentence for Mr. Prindle would be a minimum of 3 to 6, with a maximum of 25 to life in this case. And that is why this is a penalty provision as found by Justice Valentino after the 3 certified convictions, which were proven beyond a reasonable doubt, expanded the range to that amount. And that is how this court has interpreted it 7 times. We have Rosen, we have Rivera, we have Quinones, we have Bells, Battles, and Giles. And each one of those times, this court has upheld its interpretation of the statute.
Well, but we said that it changed the range. We didn't specifically say that the range went down to, as you say, a minimum of 3 to 6. In other words, if the, after step 2, right? If the additional factors are found,
Yes.
then there is no discretion to go to 3 to 6, is there?
Again, I believe that, and this is my interpretation of the case law, that it does expand the range, and it does give the court the ability to sentence within its discretion.
Well, if the court found that all of these factors rendered it necessary to sentence someone as a persistent felony offender, then how can you say that the court can sentence to 3 to 6?
Because the court still has discretion at that juncture. It's my understanding of the law that the court has to find that the penalty is appropriate. And I think that's why this provision is so beneficial
But
to...
isn't that what those findings say, is that the penalty is not appropriate? It just seems inconsistent to me.
That the penalty, I'm not sure I understand.
If the court finds those factors, that the lower range is not appropriate.
I think the whole point in this case is that there is discretion, but that discretion is based solely upon expanding a range based on the fact that the person is proven guilty beyond a reasonable doubt, and that's what elevates the sentence and expands it. And that's my reading of the case law. And I just think it's really critical for this court to look at the stare decisis principle, that the law in New York should not be changed based on a new court. I would just note that in this case, when Prindle first came before this court, it was a 3-4 decision. We don't get the opportunity to come back and argue that this was a depraved indifference murder. This was a terrible case. And we appreciate that we don't have that availability to do that. And we would ask that this court uphold its prior precedents. I think that's so important. And I don't believe that anything in the law has changed. And I would ask this court to continue to follow the Supreme Court's decision until the Supreme Court rules otherwise. I don't believe there is anything whatsoever that has been changed in the law. And based on that, we go back to preservation, where this case was not preserved for this court's review. So I would ask this court to uphold the Fourth Department's decision unless there are any further questions.
Thank you, counsel.
Thank
Mr.
you.
Hobbs?
Thank you, Your Honors. First of all, again, on this court's prior precedent, this court has never addressed the question of when the lower end of the range becomes fixed or becomes a mandatory minimum. I say that it becomes a mandatory minimum. It may be available again after step 1, but it is a mandatory minimum only after step 2 and after those findings that go beyond the fact of prior convictions. And I say that because the Fourth Department, or not the Fourth Department, every department, all 4 departments have said so. They've said that it's the minimum permissible sentence once the court has adjudicated him a persistent felony offender and made both sets of findings. To the nature of the findings. The nature of the findings are that a PFO sentence should be imposed, that a lifetime supervision is warranted in the public interest. And 3, the record here. The record here shows that the sentencing hearing took place after the PFO findings were made, and everyone in that courtroom understood that it was going to be a life sentence at that point. And the defense counsel expressly said, I would like you to impose the minimum of 15 to life, and that's what the court did. He got that minimum. He wasn't going to get anything less than that. As the questions have suggested here, some of the court sees the step 2 as a selection, basically. Do we go ahead with the PFO range, the A1 range, or do we move back to the normal range? And if that's what's going on at step 2, that is clearly outside of the scope of Allain. Allain says there is a room for sentencing discretion to pick a sentence within a range. That's always been allowed. But what's not allowed is exercising discretion to determine what the range is.
But we've said, and clearly I think in Rivera as anywhere else, that it's clear that the prior felony convictions are the sole determinant of whether a defendant is subject to a recidivist sentencing as a persistent felony offender. That's the range. So it increases this range, but the sole determinant of getting you to that range are the felony convictions. So I don't see how Allain changing, okay, now you're looking at the mandatory minimum, and Allain was a very different scheme, how that affects that analysis where we've said, and we've said it time and again, that the sole determinant to getting you to a range with a minimum and a maximum are the prior convictions.
Because that range is clearly not mandatory. That minimum there is clearly not mandatory
Maximum
until
under
after
your
step
theory.
2.
But neither is the maximum under your theory.
But a maximum doesn't have to be mandatory. A maximum is what's the maximum
Right,
that's
but the ruling
authorized.
in Apprendi wasn't that it had to be a mandatory maximum. The ruling in Apprendi was if you changed the available maximum, it was a violation. So under your theory, we would have violated Apprendi by changing the maximum available for the judge to select within.
I don't agree, Your Honor, and it's because there's a difference between maximums, when a maximum becomes available and when a minimum becomes mandatory. Those two things function in a different way. The maximum becomes available after step 1, and maybe the minimum provisionally moves up, but it's only provisionally moves up. It still is available for the court to go below that. And once the court cuts off that option by making additional findings, it has made that minimum now, as a matter of law, a fixed minimum. It hasn't cut off its discretion to go any lower. And that's the very function of a mandatory minimum, to cut off discretion.
Thank you, counsel.